It is my pleasure to inaugurate the webinar series on international investment and commercial arbitration, co-organized by Macchi di Cellere Gangemi, Studio Legale, or law firm in Italian, and the Cairo Regional Center for International Commercial Arbitration, the CRCICA. The title of the first topic of such webinar series is Counterclaims in ISDS, Challenges and Prospects in Light of the Current Reform Process of International Investment Law. Indeed, the topic of counterclaims in investment arbitration has received the attention of many authors from among arbitration practitioners. It pertains to matters of jurisdiction and admissibility, as well as to the wider topic of the reform of the ISDS regime. Today, the subject will be addressed from different angles by four notable arbitration practitioners, whom I am delighted to introduce. I will start with the distinguished moderator, Ms. Meg Kinnear. Meg Kinnear is the Secretary General of the ICSID since June 2009. She worked as Senior General Counsel from 2006 to 2009 and Director General of the Trade Law Bureau of Canada. Prior to this, Ms. Kinnear also worked as the Executive Assistant to the Deputy Minister of Justice of Canada and Counsel at the Civil Litigation Section of the Canadian Department of Justice. Ms. Kinnear has frequently spoken on and published with respect to international investment law and procedure, including as co-author of Investment Disputes under NAFTA. It's a Kluwer publication of 2006. Ms. Kinnear holds degree from the University of Virginia, an LLM, and McGill University, an LLB. She is admitted to the bar of the Law Society of Upper Canada, Ontario, and the District of Columbia Bar. Moreover, I am delighted to introduce Professor Mohamed who will be our first speaker. Professor Mohamed is a professor and chair of the International Law Department at the Cairo University. He is the founder and managing director of Amr and Partners law firm in Cairo. He is an attorney at law since 1987. He holds a PhD in public international law from London School of Economics and Political Science, University of London in 1997. Currently, he is a board member of the General Authority of Foreign Investment, a member of the ICSID panels of arbitrators and conciliators, delegated by Egypt to ICSID working group to discuss and negotiate the proposed amendments of the ICSID rules of ICSID. He is a member of the CRCICA Board of Trustees, and he regularly serves as arbitrator under various rules, including the CRCICA rules. Further, I am very pleased to introduce Dr. Anna De Luca, who is an off-counsel at the law firm Macchi di Cellere Gangemi in Milan, so the co-organizer of this event in Milan, in Italy. She holds a JD and a PhD from the University of Milan, Italy. She has been practicing in the field of investment arbitration since 2007. She is a member of the ICSID panel of conciliators, delegated by Italy to the UNCITRAL Working Group 3 on Investor-State Dispute Settlement Reform. She is a member of the Academic Forum on Investor-State Dispute Settlement and a member of the International Law Association Committee on Rule of Law and International Investment Law. She is a frequent speaker at international conferences and seminars on international arbitration, and a published scholar, author on numerous articles and book chapters on international investment arbitration. Her recent publications include Anna De Luca and others, The Duration of ISDS Proceedings, AF Research Paper, the Journal of World Investment and Trade 2020. Finally, I am delighted to introduce Professor Dr. Mohamed Salah Abdel Wahab. And of course, he is a tough leader in the who's who of the GAR. So his resume is quite intensive. So I will try to select some of his achievement in the field of international arbitration. So he is the founding partner and head of international arbitration, construction, and energy groups at Zulficar and Partners law firm. He is the chair of private international law and professor of international arbitration at Cairo University. He is the vice president of the ICC International Court of Arbitration, and he is a member of the CRCICA Advisory Committee. He has served as arbitrator, counsel, and legal expert in more than 200 arbitration cases involving African, Asians, Canadian, European, Middle Eastern, and US parties. Professor Abdel Wahab has been selected to feature in Who's Who's Legal Tough Leaders, International Arbitration, since 2017. Professor Abdel Wahab has delivered lectures and speeches on hot topics in ISDS in several countries. He acted as arbitrator and counsel in several ISDS-related disputes. He has published many articles in the field of ISDS. And now I am delighted to leave the floor to the distinguished moderator.
Thank you, Dr. Selim. I'm delighted to join everyone today. And what I would like to do is start this presentation by setting the context of the discussion. Counterclaims in investment treaties in particular can be a little tricky. So I thought it would be useful to at least go through the outline. It's important to recognize that about 15 to 20% of all investor state cases actually are based on a regular contract. So for example, a contract where the state signs and enters into an agreement with a specific investor. And under that agreement, both the state and the investor have obligations. So you can think, for example, of a situation where the investor is under an obligation to manufacture and deliver certain goods to the state or a state agency, and the state in return will have to pay for those goods. It's kind of a basic transaction. And you can easily see how in that context, the state might bring a counterclaim. For example, if the investor didn't deliver sufficient amount of the goods, or any of those kind of usual counterclaim situations that I think we all know quite well. So we see those in investor state. But where the issue becomes more complex is where you move it to the investment treaty context. And that is where consent to arbitrate is found in an investment treaty. And why this becomes a bit more complex is because of the basic structure of an investment treaty. We know that investment treaties impose obligations only on the states signing the treaties and not directly on the investors. So for example, if you had an Egypt-UK bilateral investment treaty, Egypt would have obligations and the UK would have obligations, but investors who could start arbitrations under those treaties would not have obligations. So you say to yourself, if the investor has no obligations, what would be the legal basis for a counterclaim by a state against them? Could a state even have a counterclaim? And logically, you might come to the answer, no, there should be no counterclaim. However, several investment cases have found that in very particular circumstances, the state could have a counterclaim against the investor in a treaty case. So the question is, what are those particular circumstances? And there are a couple. The first one comes out of the clause allowing consent to start an arbitration. And where it is a very broad consent to arbitrate clause, the ability to bring a counterclaim has been found by tribunals. So for example, there have been some cases where the treaty says you can bring arbitration for, and I quote, all disputes regarding an investment. And where you have that kind of a broad arbitration clause, some tribunals have said, well, that includes jurisdiction for the state to bring a counterclaim. Whereas more narrowly worded clauses, for example, you can arbitrate a breach of an obligation of the state under this treaty, the tribunals have held no, that specifies only the state's obligations, and so there is no state counterclaim. The second circumstance the tribunals have looked to is whether there is an applicable counterclaim rule under the rules applied. So most of the time you have the ICSID Convention and ICSID rules. And the ICSID Convention specifically says that except as the parties otherwise agree, you can have a counterclaim arising directly out of the subject matter of a dispute, provided it is within the scope of consent of the parties and otherwise within the jurisdiction of ICSID. So in principle, there is the ability to bring counterclaims at ICSID, but you have to meet those criteria. Does the counterclaim arise directly out of the subject matter of the dispute? Have the parties consented to arbitrate a counterclaim under the treaty? And is there otherwise ICSID jurisdiction? And that involves the whole question of Article 25 frequently. You get similar issues or similar criteria under the UNCITRAL rules, which also allow for a counterclaim. The third set of particular circumstances that have been raised is really what you might call privity issues. And the question is, even if there is jurisdiction for a counterclaim, does that counterclaim belong to the states? So for example, if the state is a party to the treaty, but the counterclaim belongs to some other state agency, can the state bring a counterclaim based on that document? And sometimes yes, sometimes no, depends on the facts. An even more difficult situation is, for example, where the counterclaim is based on environmental harm done by the investment. And the question is, does the state own that claim? This leads to an even broader discussion that we've heard in investor state, and that is, shouldn't we think about bringing more obligations? Should it not be just the states, but rather, shouldn't the investor have positive obligations? For example, to act in a socially responsible way, to remediate environmental damage, maybe to follow human rights norms in the states, to meet local health and safety standards. There have been discussions about trying to bring all of those obligations on the investor into the treaty. And of course, you can see if you did that, there would be yet another basis, and probably a stronger basis, for counterclaims based on all of those issues. So that is the basic context for this discussion. And what you're going to hear today is a little bit more from experts in the field about how treaties deal with counterclaims, how the ICSID reform process is dealing with counterclaims, and how the UNCITRAL reform process is dealing with these matters as well. And we're going to hear from each of our speakers, and then we would be delighted to have questions from the audience. And I think you are probably well familiar now with the question or chat box with the technology. Please do feel free to bring up those questions. And at the end, we would like to ask you some questions in the form of a poll or voting. So I'd like to turn now to Professor Amir, who is one of our favorite delegates for the ICSID reform process. And so he's going to share with you how that reform process is addressing the question of counterclaims. Professor Amir, over to you.
Thank you very much indeed, Ms. McNair. I'm really delighted and honored to be on this panel, moderated and chaired by you. And it's really difficult for me to address such topic while you are around. So it makes it difficult, but I will try my best, and I will rely on your support. And I would like to congratulate you for the trust vested in you for your renewal new term, and I wish you all the best. Let me first, I don't know whether we can share some slides with the participants. Is this on the screen now? Okay.
Yes, Professor.
Okay, thank you very much. let me try to. It's all right. It's okay. I will. I mean, I don't want to take time with this presentation, so I'll try to be brief as much as I can. So we open the discussion, which I believe that we all really in need to hear each other, especially at this moment where ICSID is working hard on revising its rules and propose, thanks to the efforts of Ms. McNair for her extensive efforts that she made for the last 2 years, and the team of ICSID really, and which is, I hope that will be these rules will come into force soon, and will meet the acceptance of and approval of the state parties. But as you know, that the ISDS, I mean, faces a lot of challenges at this moment, and I'm not going to say everything in details, but it's on the screen. But what I'm saying is that many, not many, let's be positive, but some states are reluctant now to accept the any clause or treaty or an agreement which refer to this system, investor-state dispute settlement, because they fear. And when they fear, they don't like, I mean, they build up kind of repetition that this kind of arbitration is against us. They don't consider our interest and so on. And this led that some states, they already withdrew from the exit convention. Very little, very few states, but there is an indication which impose on all of us a responsibility to make sure that this system is acceptable, credible, and attractive to states. And one of the issues is the counterclaim. Because when the state feels that they will have the right, at least to present their claim to the investment arbitration, will be a kind of helping them, and will help us promote the goals and the efficiency of this kind of arbitration, investment arbitration. So will also grant equality and fairness between the parties, as we see in all commercial arbitration. So, I mean, when we talk about the counterclaims and can we use the counterclaims in investment arbitration, some people might not consider that this possibility is granted by Article 46 of ICSID Convention, which provides that the states and any other party, if requested by a party, determine any incidental or additional claims or counterclaim arising directly. So the legal base is there. So we can build on that. And this is complemented by Rule 40 of the arbitration rules, which in a way grant or complement what is said in Article 46. And it says, except as the parties otherwise agree, a party may present an incidental or additional claim or counterclaim arising directly out of the subject matter of the dispute, provided that such claim is within the scope of the consent. And this is what Ms. McNair addressed a while ago, and within the jurisdiction of the city. So those are the two conditions that will we have to consider when we are talking about the counterclaim under this system. This is the counterclaim. I don't want to, I'm sure that all the participants are familiar with that, but I would like to give the concept of counterclaim is not a new one, especially under UNCITRAL arbitration rules, PCA arbitration rules, ICC rules. So all these rules, I mean, sometimes they deal with investment disputes. So ICSID is also will be moving in the same direction with all these institutions when we grant such rules. The jurisdiction prerequisite, the parties must consent to submit counterclaim. and this is the key, and must be within the jurisdiction of ICSID. And this is another key, because the parties must consent. Will be only based on either a treaty or agreement. So we must make sure that any new rules that will be adopted in this direction will grant that, open the door for the states to have access and can submit their counterclaim. So the jurisdiction pre-request, admissibility pre-request, which we will address in a while. The consent can be expressed by a treaty or by the agreement, and at the end of the day, this depends on how the arbitral tribunal will deal with this matter. So in some cases, some tribunals, they adopted a restrictive attitude, and in other cases, they adopted a flexible one, whereas they permit the member states to present their counterclaim in the dispute, which, in my opinion, I believe this would be a great support of the system at large. One of the problems that we face is that when we look at the arbitration clause itself, because in some cases, like the BIT between UK and Venezuela, it limits the possibility. So the problem here, it does not come from the rules, but from the agreement of the states. And in this case, I hope that all the states, when they revise their arbitration clause, whether it's in agreement or under an arbitration treaty, they try to push for an open way, or to allow themselves to be parties to a dispute before ICSID, when they would like to submit their counterclaims. So this will help the system and will help to attract member states to trust the system. So under ICSID rules, there is a connection requirement between the principal claim and the counterclaim in order for the latter to be admissible before the tribunal. And when courts, when we review the awards that issued by the courts, we notice that they try to make the connection, and they require that there is a connection, whether a factual and or legal, and they try that the factual connection is established when both claim and counterclaim are based on the same investment. The legal connection may be established when both parties pursue the same legal aim, which in most cases, the recognition on the basis of the same rules of legal instruments. For example, if a claimant bases its claim on an article of a treaty, the respondent should be able to file a counterclaim based on another provision of the same treaty. I believe that we notice these days, with the effort of ICSID led by my Ms. McNair, when I am not going to present everything said on these rules, but I would like, to respect the time limit. So this is the last version, the working paper number 4, which is a new proposed amendments to the which reads as follows: unless the parties agree otherwise, a party may file an incidental or additional claim or a counterclaim arising directly out of the subject matter of the dispute, provided that such ancillary claims is within the scope of the consent of the parties and jurisdiction of the An incidental or additional claim shall be presented no later than, this is the time frame to be presented, in the reply, and any counterclaim shall be presented no later than in the counter memorial, unless the tribunal decides otherwise, and the tribunal shall fix time limits for written and oral submission on ancillary claim as required. This is the last version. I'm sure that Ms. McNair will let us know where we stand and whether we will have any possibility to improve in order to open the door for the states to submit their counterclaim. But I am of the opinion that anything that will open this clause in order to allow states to feel freely to submit their and file their incidental and additional claims or counterclaim, which is hopefully arising directly out of the investment. So we open the door wide, and this is, I'm sure that we all know the benefit of having such a possibility, that this will have a positive impact on the system, which we all keen and we will all trust, and we need to work under this system based on a long experience, more than 50 years now of being an international body that its main concern is to protect investments, and protection investments is not only to protect the investors, but also to protect member states. So we make it open for everyone to claim whatever they want before the tribunals. I'll stop here, and I would like be happy to, if you have any comments or questions, to reflect on what I have said. Thank you very much.
That's tremendous. Thank you very much. I don't see any questions immediately. And so why don't we pass now to Dr. DeLuca? And Dr. DeLuca is going to address how counterclaims are being spoken about and reformed through the UNCITRAL Working Group 3 process. Dr. DeLuca.
Good afternoon to everybody. First of all, I apologize for joining you with a delay. Unfortunately, I had a few technical issues and problems. So really, my apologies. Then I confess I skipped the presentation by Dr. Selim. And the initial part of the introduction by Meg Kinnear. So I'm really sorry for that. And then let me thank Selim, Dr. Selim, for having accepted to organize with Macchi di Cellere Gangemi and more specifically Francesco Bentivegna and me, this web seminar series. Many thanks to my co-panelist and the chair for having accepted our invitation to speak at this web seminar. Now let's go to the topic I have to deal with, counterclaims in ISDS in light of the UNCITRAL reform process. Where do we stand? The topic of counterclaims has been the object of some discussion within Working Group 3, albeit I have to say the topic has been excluded from the ISDS reform mandate. In other terms, there is no consensus within Working Group 3 on the need to deal with respondent states' counterclaims. However, such discussion there was a discussion on the topic, and I have to say the discussion, at least until now, has to a certain extent lacked sufficient depth and has largely remained unfocused, with the group asking the Secretariat the preparation of background notes and proposal. I believe that the discussion is not going to end with the proposal of treaty drafting options acceptable and valid for all. And this depends on a number of reasons. I would say the first one is the dual nature of counterclaims. Namely, counterclaims have not only a procedural but also a substantive nature. Additionally, the discussion has been made more complicated by the introduction into the discussion of the suggestion that counterclaims may be used as a general means of adjudicating human rights related obligations of investors. So as far as concerned the dual nature of counterclaims, it is generally understood that international law that a counterclaim is an independent claim by the respondent against the claimant for being the latter responsible for the breach of the obligations it owes to the former. And at the same time, it is a quote from the case law of the International Court of Justice related to the principal claim insofar as it reacts to it. So a counterclaim operates as a defense to the principal claim on the one hand. On the other, it distinguishes from a defense in that it aims at obtaining something more than the mere dismissal of the principal claim. As a consequence, I would say the counterclaim extends the scope of the proceedings to a new claim, and this new claim, albeit related to the same underlying dispute, is beyond the case as originally formulated by the claimant. Additionally, since counterclaims are reactive and thus linked to the original claims, they are also incidental thereto. I think that the above description evidences the basic features of and rationale, I would say, of counterclaims as operating on the international plan. First of all, the right to counterclaim is a fundamental element of a defendant's right to present its case on an equal footing to the original claimant. So it rests on reasons of fairness. Secondly, counterclaims promote procedural economy and consistency in decision-making, thus contributing to a better administration of justice. On the other hand, I would say the better administration of justice aims, including procedural economy and consistency, and the incidental nature of counterclaims limit the admissibility, in that the admissibility, and I quote once again from the case law of the International Court of Justice, must necessarily relate to the aims thus pursued and be subject to conditions designed to prevent abuse. So these two conditions for counterclaims admissibility have been mentioned by Meg Kinnear in the intro, as well as Mohamed in its speech. So I do not need to deal with them here. I just want to to emphasize here just one point, that is that the two requirements are designed to prevent a respondent from using a counterclaim simply as a tactic for undermining the effectiveness of the process or procedure available to the other party. The jurisdictional condition precludes a respondent from using a counterclaim, and once again, I quote from the case law of the International Court of Justice as a means of referring to an international tribunal claims which exceed the limits of its jurisdiction as recognized by the parties. I would add, regardless, the consensual basis lies in an arbitral clause in an investment contract or a treaty clause. Secondly, the direct connection requirement precludes a respondent from using a non-related counterclaim as a means of imposing on the applicant any claim it chooses at risk of infringing the applicant's rights and compromising the proper administration of justice. So the two requirements have been applied by both ICSID and UNCITRAL tribunal in a consistent manner, I would say, notwithstanding the UNCITRAL rules. I mean, both versions do not use the same language used by the ICSID Convention. I would add in this respect that the 2010 arbitration UNCITRAL rules do not even refer to the direct connection requirement. So I would say that the question, there is the question of whether or not such an omission might have an impact in the way, on the way UNCITRAL tribunals are going to decide on counterclaims admissibility, but I do not have time to deal with the issue here, but I would be happy to receive questions on this point. What is the dominant approach followed by tribunals in applying such requirements? According to the dominant approach, with a few exceptions, for instance, Urbazer, David Evan, Goetz versus Burundi, respondent counterclaims in the form of reactive claims grounded on a different legal basis than the treaty itself, thus I would say legally unrelated to the investor's claim based on the breach of treaty provisions, are in principle either outside the treaty-based jurisdiction of the tribunal or inadmissible because not directly connected to the investor's treaty claims. So tribunals, I would say, have applied such approach also when the treaty at stake includes first a broad ISDS clause, such as the first type of clause mentioned by Meg in the intro. Second, a broad definition of covered investment, including licenses, concession by law or by contract, or authorizations. Third, a clause on the applicable law also referring to the domestic legislation of the host contracting of the contracting parties, and finally, and in accordance with all states' legislation's provision. I would say that to use the word of the tribunal in the Saluka versus Czech Republic case, when the legal basis on which the respondent has itself relied for its counterclaim is to be found in the application of its domestic legislation, and involves rights and obligations applicable as a matter of general law, then the dispute underlining that counterclaim in principle fall to be decided through the appropriate procedures under domestic law and not through the particular investment protection procedure of the treaty. I would say this is the prevailing position, the dominant position in the case law, except where the treaty at stake contains a provision which goes beyond a general obligation upon investors to respect the host state's legislation, a provision imposing a positive obligation upon investors to respect the law of the host state. This is the case with Article 9, for instance, with Article 9 of Agreement on Promotion, Protection and Guarantee of Investments among members of the Organization of the Islamic Conference. But I think that this is an issue which is going to be dealt with by Mohamed, Abdel, Wahab. So I stop here. I just want to say that in this provision, together with a neutrally drafted ISDS clause, led the tribunal in the Albarak case to conclude that the agreement, albeit silent on the specific matter, permitted the filing by the state of a counterclaim. So, given the current trends in the case law, the possibility for states' counterclaims in ISDS is contingent upon the presence of specific underlying provisions explicitly permitting it to do so. And in fact, some treaties of new generation include specific provisions on counterclaims. This is the case of Article 14, paragraph 3 of Iran-Slovakia bilateral investment treaty. Once again, I think that maybe the article will be included in the speech by Mohamed Abdel. Another example is Article 9, 12.2 of the Trans-Pacific Partnership Agreement. But the question is, does this limited possibility for respondent states counterclaim or the impossibility result in intolerable imbalances between respondent states and investors? I think that the question has to be answered, I would say, more in the negative that in the positive, for a number of reasons. First, this limited possibility or impossibility for counterclaims by no means limits the ability of our state to enforce legal obligations incumbent upon claimant investors under its law and in its own courts. Additionally, illegalities committed by investors been from the outset and still are routinely at the basis of states' defenses against investors. So if upheld, they may prevent investors' access to ISDS or operate as a defense on the merits. Secondly, I think that competence, the jurisdictional competence of International Tribunal on counterclaims is not exclusive. And this is, I would say, even the new provisions on counterclaims included in treaties of new generation confirm these. On the other hand, I would say that a counterclaim by a state in ISDS inevitably impacts its capacity to advance such claim before other possibly competent fora, including its own judiciary. This is to say that counterclaim in ISDS has significant sovereign implications because adjudication, admission and adjudication of counterclaims in ISDS risk depriving domestic judiciary of their natural and general competence and raise sensitive policy issues related to the correct interpretation and application of applicable domestic legislation. Given this, I would say such provisions on counterclaims might not be a policy option for all states or contracting parties to international investment agreements due to internal constitutional constraints. This is the case with European Union, for instance. In European agreements, contracting parties' international commitments are delinked from their domestic legal systems. They are defined as interstate commitments, and such delinking is required pursuant the case law of the European Union Court of Justice in order to safeguard the autonomy of the European legal system, including its judiciary. From interferences by external judicial mechanisms. So this is this delinking is a constitutional constraint to European investment policy and is a non-negotiable element thereof. I stop here because I think that I do not have enough time to address the last point on counterclaims as a general means of adjudicating a human rights related obligation of investors. So
thank you, Professor De Luca. And I think that may be something we want to get back to in the question and answer. We'll turn now to Professor Wahab, who's going to talk about that treaty link, and in particular, what are new treaties, especially in the African and Arabic investment treaties, how are they addressing, or are they addressing, counterclaims? Professor Wahab, over to you.
Thank you very much, Meg. Let me start by saying such a great pleasure to be in such a great company of great people. It is so great to see that many friends and colleagues are joining us amidst the webinar fatigue syndrome, which I'm also mindful that my dear friend Funke Adekoya calls death by webinars. So we have a great turnout anyway. And I'm grateful that there are so many friends and colleagues from Africa and Italy specifically are also joining us. The advantages, and I know the word advantages, of speaking last is threefold. You have nothing to say, or you speak less because time is up, or building on what has already been said and you simply say, I concur, which is my initial position, or hopefully add something new or a different perspective, which I also will endeavor and intend to do. That said, in the next 10 minutes or so, I intend to address with you the issue of counterclaims, building on the excellent and seminal contributions by my dear colleagues and panelists, but in the specific context of African and Arab international investment agreements. And by the way, here I'm using Arab because all through North Africa is part of Africa, but I'm talking as well part of the Gulf and Asian countries, which are not, of course, on the African continent. I will start with a brief on what I call back to basics, then the diversions that exist. Then I'll move to the counterclaims under Arab and African international investment agreements, where I group them into 4 categories. No express reference to obligations and state counterclaims, express reference to a multitude of obligations under the agreements, the international investment agreements, but no reference to counterclaims, or a passing, what I call shy reference to a counterclaim, and then an express reference to a counterclaim before I conclude with certain observations on reform or system recalibration, as I call it. Now, in terms of the basics, we've got to remember something that people tend to overlook, is that international investment agreements are negotiated and agreed and concluded between states. I'm saying that to remind ourselves that the diversions in terms of decisions are not simply a function of arbitrators acting as gods. And I'm not deciding, I'm not simply saying that sometimes people do not do so, hopefully less and less now. But I'm simply saying that because the wording of treaties do differ, and arbitrators are bound by these. And the diversion trends, and many of my esteemed colleagues, Meg, Anna, and Professor Amr, have referred to a number of cases, but I put them in front of you, some of them, having predicted that they will be addressed, and I was right, but perhaps so during the Q&A. The Saluka, the Pushkok, the Rosales, the Inmaris, the Goods case, the Abasa, the Rosoro, and the Burlington, the latest arrival, which, by the way, was the first case where the tribunal awarded the state a $41 million counterclaim, first ever to be awarded. But just don't panic or think it's a huge amount. The state actually asked for 2.5 billion almost. So anyway, moving further to address the status quo of the international investment agreements in the Arab world and in Africa, where there is no express reference to obligations, no express obligations on investors as such, and no reference to counterclaims. This is the overwhelming majority. Just to give you an idea, the Egypt-Ethiopia BIT, which is in force, Egypt, Switzerland, Canada, Cote d'Ivoire, Egypt, Mauritius, UAE, Japan, Kenya, Ethiopia, Qatar. I mean, and the world even is beyond that. But in the African context, this is just a glimpse of the situation. It's about rights and about promotion and encouraging investments, and more about protecting those investments, and so the rights of the investors by and large. Then we have an express reference to a multitude of obligations, but no specific reference to counterclaims. And the one and single and foremost treaty that we champion on the continent as demonstrative of an excellent expose of a balanced approach to rights and obligations is the Nigeria-Morocco BIT, which we are all championing and all proud of. But in the specific context of counterclaims, I cannot say as much. It is a very interesting thing that I tell you that we have clear obligations, a multitude of obligations on investors. Nevertheless, Article 20 refers to investors' liability, making reference to local courts, not to arbitration. And even so, Article 27 only refers to investors commencing arbitration. So the Nigeria-Morocco BIT, which is championed and showcased as an excellent one, and it is, still, when it comes to counterclaim, falls short of providing adequate protection or perceived expectation of enabling states to pursue a counterclaim. Perhaps this is foreshadowed by the idea that states can take measures that they wish. They can pursue litigation proceedings, but no harm would be done if counterclaims are also addressed in the sense of completeness. And I go then to the Brazil approach, and I go the Brazil, Ethiopia, Morocco, and the UAE, where we don't have obligations, there are clear obligations on investors, but no reference to counterclaims. And the reason is they have dispensed with ISDS. The procedure under these treaties, the Brazilian approach, is that you have SSDS, which is state-to-state dispute settlement, rather than investor-state dispute settlement. Now, this is what I call a state-sponsored claim by investors, where the state would sponsor a claim by investor and take it forward. So think of it not just as the big brother, but as the father going and pursuing a claim against the state. So in that sense, the agreements provide for any state, being the contracting party, having the ability to commence arbitration, but it's not the investor themselves. And we've got to see, of course, what the future will say as things unfold regarding this approach. And then thirdly, the passing reference to counterclaim, which is I call by way of exclusion. And here a contracting party, the common denominator, the theme that cuts across the BITs that have this passing reference, is a reference to the contracting party, which is the state, may not assert a defense or a counterclaim or a right of set-off on the basis that the claimant, and look at the claimant, the BIT foresees that it is only the investor that will be the claimant, received or will receive indemnification from third parties. So simply saying, if you as an investor are receiving indemnification from third parties, this will not, of course, allow the contracting party to assert a counterclaim on the basis that you are receiving this type of indemnification. And this is the situation under the Rwanda-US BIT 2008, Kenya, Kuwait, Canada, Guinea, Mexico, UAE, Jordan, Japan, and the latest arrival, Morocco, Japan BIT, which is the latest on the continent. Then I come to the express reference to the counterclaims, which my dear friend Dr. De Luca has alluded to, and of course the Iran-Slovakia one, but it's beyond the realm of Arab and Africa, so I'm focusing on the UAE-Slovakia one and the UAE-Argentina ones. Here we have express reference to counterclaims. And again, I want you to note that the reference is to a respondent and counterclaim. Again, the perception is the state is not a claimant, but can counterclaim. And I'm predicting that that's going to change in the future as the system recalibrates in a way in terms of states could be claimants. And we have very minimal cases where that has happened, but I see no reason that this may not be the case, of course, subject to the wording of the BIT. Now, this brings me to the last part, and I think I'm on time, of my presentation, the concluding remarks. And here I address the past and the present, and then give very few comments regarding the future. Now, in terms of the past and the present, and they are lumped together because that is the reality of the status quo, states' arguments feature prominently as defenses and are rarely framed as counterclaims with an affirmative relief. This is not my statement. It is Stephen Chill's statement in one of the excellent books written on the ICSID Convention. The second point is that the majority of the international investment agreements, as we've seen, make no express reference to counterclaims, and the tribunal jurisdiction thereover, bearing in mind the traditional fight, whether this is an issue of jurisdiction or admissibility, the twilight zone, thereover becomes a function of treaty interpretation. Moreover, there have been, of course, issues about the nexus between the existence of obligations and counterclaims. If there is no obligation, can that give rise to a counterclaim? And we have, of course, conflicting views on this. The Rosales case is one example where the majority found that the BIT imposes no obligations, and accordingly, the obligations are only on the contracting state, and so no counterclaim. And then there have been a very clear dissent by Professor Michael Risman on this, which I hope we get a chance to address during the Q&A. It is quite an interesting one. And then the element of requiring a connection, which my dear colleague and Professor Professor Sam Hamr has addressed with Dr. De Luca. I don't intend to dwell much on it, but the issue is this proximity or nexus is an important one, be it factual or legal. And of course, there are many cases that address this requirement. Then I come to the future. And here I mentioned the new model texts. One example on the continent is the Pan-African Investment Code, which Article 43, Paragraph 2, provides guidance to member states who enter into international investment agreements, saying that a member state may initiate a counterclaim against the investor. And in that sense, it has inspired, and I think it will continue to inspire, a rebalanced approach to international investment agreements. And I think one element that we tend to overlook is that investors do not seem to be opposed to the introduction of counterclaims, by the way. And we have precedents in the few cases where counterclaims have been introduced. The Abasa case, the tribunal noted that the claimant has admitted that there is no rejection or refusal, taking the ratione persona element of the treaty, on who may bring a claim. And in fact, that was an inspiring point that the tribunal endorsed. And even in the Burlington versus Ecuador, the investor signed a compromise which allowed Ecuador to pursue their counterclaim. So the idea that there is a diametrically or opposed or polarized views that are against the admission of counterclaims per se could be more theoretical rather than practical, given that a fair percentage of the minimal number of cases addressed do show that investors do not mind that being the case. The new generation, and my last point, the new generation of international investment agreements, my thoughts is that they would expressly make reference to claims and counterclaims, not just counterclaims. I think there will be claims as well, with the ability to request a joint interpretation. And here is a fascinating issue that I address before I conclude. We have, for example, the Indian model BIT makes express reference to counterclaims, and I think it offers some good guidance. And on the continent, stay tuned, because the Africa Academy is doing some work in that field, and I think it will as well provide some illuminative views in this respect. A contracting party may initiate a counterclaim, and here note the reference to a contracting party, not necessarily an investor or the state. They can trade positions as a claimant and respondent. And I think the element that is quite innovative and helpful is that the assertion of a counterclaim that does not dispense with or constitute a waiver of an objection to jurisdiction regarding an investment dispute. When you've got wording like this, you make the life of the tribunal easier, you make them less under pressure, the parties are well aware of what they agreed and consented to. And the final point that I end with is the Rwanda UAE BIT, which provides, of course, under Article 14, refers to an investor-state dispute. That's the broad interpretation commenced by either party. But I'm more interested in 17.2, which refers to a joint interpretation being received in a timely manner and will be binding on a tribunal. So perhaps the new generation of the BIT, the way out of it, to ensure consistency, predictability, and avoid the diversions, is that perhaps if we pursue an ISDS situation, nothing would prevent a tribunal, if the wording of the BIT so allows, from seeking a joint interpretation from the states regarding an ambiguity or a lack of clarity or a gap in the agreement itself. And if the states are in agreement regarding a joint interpretation, then this would be of guidance to the tribunal. That, of course, should be taken with a grain of salt regarding not only the integration of this wording into the BIT, but the timing of it and whether this would have an impact on the investor's claim. So I think this joint interpretation is quite innovative and perhaps requires some degree of reflection. With that, I end, and I thank you very much, and I'm looking forward to our Q&A regarding perhaps certain cases regarding this counterclaim. Thank you very much.
Tremendous. Thank you, Professor Wahab. We've had a number of really good questions come up as we have been listening to the speakers. So why don't I just go back and move through them? The first one was one as Professor Amir was talking, and the question was, what would the situation be if the counterclaim is brought based on activity that doesn't arise out of the investment? Professor Amir, what do you think the reaction of a tribunal would be in that circumstance?
I am in favor of allowing states to file counterclaim, but at least there must be a link to the investor and to the investment. It's not an open check. I don't mean at all that this is an open check. Otherwise, we will abuse the process. But in my opinion, and I don't like that we describe the counterclaim as a way of defense, because this is not also a way that given to the state to defend the claim coming from the investor, but the state should respect the idea behind the counterclaim as a process, as a legal process, that if they have the claim in relation to the investment, regarding the investments on ground presented by the investor, then the state must be allowed to have such option. But and that's why we need to be very careful for any future rules on this regard, that we don't let the states prevented from exercising this process, but at the same moment we don't allow them to abuse it or to be used as a way of defense, not as a way to present a serious claim before the investor. And as you know, I mean, the scope of investment now is getting wider. So, so sometimes it's related to environment, sometimes human rights, and so on. So we have to make the right balance when drafting these rules, whether in our rules in ICSID or the treaties or agreements between investor and states. That's my point.
Exactly. Professor De Luca, as you were speaking, there were a few questions. First of all, do you feel that the right to counterclaim should be written into the treaty? Would that be your proposed approach?
You're on mute.
Mute you.
Anna. That's normal in webinars and in hearings, to tell you the truth. It is a very common.
I mute the microphone because you and the other were speaking, and then I forgot to. Then, as to the question, I think that considering the restrictive approach in the case laws, my answer would be yes. In the sense that even an ISDS, a broad ISDS clause might be applied by a tribunal in a very restrictive manner. And so even I would say counterclaims by a respondent factually related to the treaty claims of the claimant, but not legally, because based on the breach of domestic legislation might be excluded from the scope of the jurisdiction of the tribunal. This is notwithstanding, as I said, I really believe that whether or not, I mean, the admissibility of the counterclaim, of a certain counterclaim, does not really depend on the fact, cannot depend on the fact that the investor is the only one that can trigger the procedure under the treaty. I would add that in this respect, that even, for instance, I really consider that somehow tribunals have started, have assumed, I would say, that I mean, absent specific provision on counterclaims, the respondent states do not have the right to counterclaim, which is bizarre because for instance, other international tribunal operating outside the field of investment protection, For instance, I can quote the arbitral tribunal in the Erika Alexi incident, consider that even when the right of filing counterclaims is not expressly provided for or regulated, international tribunals, I quote, have the inherent power to hear counterclaims, thus giving each party a full opportunity to be heard. So we have, I stop here.
But I think we've had a related question for Dr. Wahab, and maybe it's the flip side of this coin, but the question comes from Aman Kumar, and he says, isn't a counterclaim an inherent part of a BIT when you have an ISDS clause that says, for example, a dispute about arising out of the investment? So isn't just it inherent in the BIT, and why do we need to take all these other measures to make sure a counterclaim can be dealt with by the tribunal? Dr. Wahab, what is your thought?
Yes, thank you very much. An excellent question. That also allows me to complement what my colleagues have provided as excellent comments. Let me say the wording, as I mentioned, and I think back to basics, tribunals take good care of the wording of the BIT, and that's part of the interpretation that tribunals in an international law context, applying the Vienna Convention on interpretation of treaties in a way, would look into that wording. If the wording is broad and in the passive language, referring to all disputes concerning the investment, with a neutral reference regarding the ratione persona of who's commencing the case, then absolutely yes. Then nothing prevents that in principle, of course, bearing in mind the nexus that has been emphasized earlier in the earlier question regarding the claim and the counterclaim. But let me say the following, even on that nexus, we have to be careful because, for example, we know that umbrella clauses exist. And so far investors have been relying on umbrella clauses, which are, by the way, less and less integrated into treaties and the new generation of treaties. But imagine if you have an umbrella clause in a neutral language regarding a breach of contract, nothing would prevent the state in principle then to elevate a breach of contract to the level of a breach of treaty, relying on an umbrella clause in the same manner that an investor was doing. And that is a sort of the symmetry that we can see in treaties. Now, the problem with the question that Kumar has posed is that the wording of treaties are not always straightforward. Remember that I emphasized the words claimant and respondent. Remember the Nigeria-Morocco BIT talking about the investor commencing the arbitration. Now, this is not neutral in a sense in terms of giving a party the right to make a claim, and apparently on the wording, subject, of course, to not just circumstantial evidence, but the proper reading of all provisions of the treaty may deny that right. So on the broad wording, we've seen that all disputes, for example, existed in the Saluka versus the Czech Republic case, the Pushkok versus Mongolia, the Inmaris versus Ukraine, which the tribunal, by the way, procedurally admitted the counterclaim but dismissed it on the merits. And then, of course, the Elbasa versus Argentina. But on the Rosales specifically versus Romania, I think what is of use and help is to be reminded as well of the dissent that Michael Risman has provided regarding jurisdiction of the counterclaim, where he said the consent component of Article 46 of the ICSID Convention is ipso facto imported in any ICSID arbitration pursued by an investor. And he went on to say that to state otherwise, which was the majority's view, would lead to duplication, inefficiency, and absurdity by forcing a respondent state to resort to its own courts to resolve issues that have arisen in the counterclaim context. I would also conclude on that question by saying that the approach of Risman was followed by the Goods versus Burundi case in a way. So in effect, the wording could be broad, could be narrow. The whole premise and the rationale of the BIT could be premised that the states did not anticipate the idea of a claim or a counterclaim, or the state envisaged that but dispensed with that requirement because states have other alternative or options. I think the idea that the tribunal needs to explore the fact-to-legal matrix of the case would save a lot of time and expense if we have clear guidance in the wording of the BIT as to what the approach taken by states would be.
Good. We have a very interesting question from Mustafa Abdel Hamid, and that's posing the question of enforcement. And the scenario that he poses is where you have a case where the state brings a counterclaim. The investor claimant is not successful in their first claim, their primary claim, but the state is successful in the counterclaim. And the question is, how is that counterclaim award, per se, going to be enforceable? It's an interesting scenario, but when you think about it, a plausible one, especially as you make counterclaims more and more available. Any thoughts? Yeah, thought it was a good question.
I'm always happy to take the front and take the bullet in my when it comes to difficult questions. Let me say the following: it's an excellent question, but I think it's not something that is very difficult to handle. I think the scenario we're talking about is a claim is in it more or less denied or dismissed, but the counterclaim is granted. And here we have to look at the instruments that are applicable. If we're in the context and in the realm of the ICSID kingdom, as I would say it, then under the ICSID convention, of course, the controversy whether you would use the New York Convention or not, but the ICSID is a self-contained mechanism, and you have a self-enforcement tools under Articles 55 or 57. I think it's something Meg would correct me on that. Of course, you have a self-enforcement, and that can give that option. Now, if you're in the realm of UNCITRAL arbitration, PCA, Stockholm, ICC, you would resort to the New York Convention as an enforcement of an arbitral award as things stand. If you are in the realm of the OIC or in the realm of potentially the Arab Investment Treaty, where enforcement is within a period of 3 months, for example, then in that sense, you can also pursue enforcement. I think the question is not one of conceptually being able to pursue enforcement. The question is one whether you can find assets to pursue enforcement and spend much more money regarding enforcement in a way, which brings to the mind as well the issues about adverse costs, which is something for another day, not for today.
Exactly, but a full possibility. Professor Amir, Professor DeLuca, any thoughts on the enforcement question?
I would say that I do not have anything to add to what have been said by Professor Wahab. The only probably additional point I can make, but I'm not sure it is relevant in respect to the question raised, is whether or not depends on whether or not the award is expressed in monetary obligations, whether or not
Sure.
this is the case, because then I see a few problems under the ICSID convention. It is true that ICSID awards are binding, but it is also true that under Article, I think, 54, you can correct me, the enforcement the article referred to the enforcement of monetary obligations. So, and this is might be an issue under the ICSID convention.
Okay.
And we, of course, have the Argentina. Remember the Argentina in 2018, where they said, no, enforcement is not necessarily subject to ICSID, and they took it in their own hands in a way.
Exactly. No, it's an interesting multi-layered question. We had another question for Dr. Wahab, which is, what would be the legal value of a joint interpretation of a bit with respect to counterclaims?
Thank you very much. I think a joint interpretation would have a value that goes beyond the four corners of counterclaims. If we enter into the realm of joint interpretations, and if that is an option, now we know, for example, that the US approach sometimes is to have an interpretation annex that tribunals will be bound of. So it's actually telling the tribunals, no, you don't get to interpret the agreement. This is how the states want it to be interpreted, and that's then binding on the tribunal. It's not a matter of travaux préparatoires. It's not a matter of something guidance. It is binding on tribunals. But the provision that I referred to in the specific BIT refers to joint interpretations that could be timely before the tribunal, and it's mentioned received, which is quite interesting. It's in the passive voice. And that begs the question, can the tribunal request a joint interpretation from the states? That's one question. And secondly, will the states join forces, perhaps against the investor, to give an interpretation that would throw the claim out of the window? Will that be motivated by political or whatever factors? A very legitimate question. So there are a number of parameters to consider. But assuming the principle is there and joint interpretations are a possibility, I think it would be of utmost benefit to tribunals when the question is clearly ambiguous, when it's on the borderline, to seek this joint interpretation. The states may or may not provide them. If they are provided on the basis of a binding provision in the treaty, then it is binding on the tribunal. And to that extent, it can apply to the claim, to the counterclaim. It can apply to aspects of provisions on the treaty. One thing that we see in treaties that is increasingly under attack, and we see divergent views on, is the application of MFN clauses to jurisdiction, and forum selection clauses. And I think, and I'm reminded again of the words of Brigitte Sten, Professor Sten, when she said, this cannot magically transform the MFN clause to give jurisdiction. But again, I state no view on that. It depends on the treaty. But I think there are elements in international investment agreements that can benefit of a joint interpretation. And this will be then expressive of the common intent of the drafters that will help them. The question, of course, that remains unanswered is whether an interpretation given years after the treaty has been concluded would be reflective of a true common intention of the parties at the time of concluding the treaty. That's a philosophical question, maybe again for another day.
Exactly. The whole retroactive nature of a joint interpretation was one of those big issues under NAFTA and the whole fairness question. Daniel Schwa has brought up a question or a thought that I actually came to me as well when I was looking at this. I think it's very interesting. And the question is, since basically a counterclaim can only come up once you have the primary claim, would putting more ability to make counterclaims actually act to incentivize states to try and seek conflict so that there is a primary claim and you can then have a responsive counterclaim? So is there the potential for kind of a negative situation where you create more conflict as opposed to less?
I'm happy to say the first word, and then Anna can comment, and Dr. Amr and Professor Amr can do this. I don't see this as a possibility at all. And the reason is practical. States will not normally spend time and money potentially on filing claims. They have their own measures to take. They have their own proceedings to do. That's a possibility. I think the counterclaim option comes as a byproduct, not just as a defense mechanism, but as a countermeasure. Think of it this way, and I don't want to, but I don't want to bore people. It's a match. Imagine it's a football match. And instead of you being the goalkeeper, trying to avoid goals being scored, you now have a striker who can score goals as well. So the possibility of back and forth game could then not just motivate more disputes. I would venture to say it may even result in a situation where less disputes are on the table. Why? Because investors will think now about the prospects of bringing a claim and thinking of a counterclaim being filed against them. So firms and counsel would then factor into not only the success of the claim, but the prospects of a counterclaim and the success thereof. More work for counsel, but I think it does balance the equation in a way about the likelihood of disputes arising.
So the advice would be careful what you wish for, I think. Dr. Amir, any thoughts on this?
Yes,
or?
I mean, I totally agree with Professor Wahab actually on this, but I really don't like to be seen as saying that the counterclaim is a way of defense or to strike the investor or to beat the investor. It is a legal process, and the state, once they accepted to be a party to this relationship, the investor should consider that and put that into consideration. They should not fear from, as we do in the commercial arbitration. I mean, it's everyone is exposed. If you do any claim, that you will be faced with a counterclaim.
Exactly.
Same here applies, and I mean, it did not affect negatively the commercial arbitration. So why there is a fear that it can affect the investment arbitration?
We have some tremendous questions, but I'm conscious of the time. Let me just add one more, and that is a question or the point being raised that if you have the right to initiate counterclaims, and if you start building in more clear obligations on the investor, does that have some kind of implication for allowing security for costs and third-party funding clauses? And I assume part of that is security for costs against either claimant or respondent, and third-party funding clauses or prohibition, depending on what you put into that, with respect to third-party funding received either by the state or the claimant. Any thoughts on that?
I believe that this will make it a bit difficult if we accept, open the door for the counterclaim to be presented and filed by states. This will make it a bit difficult for a third-party funding, because will change the mechanism of the funding, because maybe will introduce a new element. If the third-party funding will think and take into the consideration, what if there is a counterclaim, and what if an award is issued in favor of the state? So will this be a part of the agreement between the investor and the third party? And because the third party funding must consider this possibility and this scenario, because at the end of the day, this might affect the claim itself, or affect the award in the future if the tribunal dismissed the claim, the initial claim, and issue an award in favor of the state.
Do you think it might bring up third-party funding of counterclaims separately from
That would be funny.
That was my point, Meg, actually. I was going to say, to complement, and I concur with Professor Amr, I was going to say it will open a new stream of business for third-party funders to fund counterclaims. And the interesting thing, and that's the wave I see possibly coming in the future, you may have a situation where if the state defaults on paying the third-party funder their share, you may have an investment claim by third-party funders against the state, assuming that qualifies as an investment, which is a new stream. So it's a totally new world. Totally. And it's an interesting point. So yeah, again, be careful what you wish for. You open that door, you open a new stream of business, and then we may have further topics, further hot topics to talk about.
We definitely have many hot topics. Let me try and bring this to a close. We wanted to have the audience vote on a couple of questions or a couple of thoughts that come out of this. And if I could ask the administrators here, if you would put the first question on the screen. And for the audience, you will be able to vote. We made them basically yes or no questions. But the first question is, should states expressly provide for the right to counterclaim in their new treaties? Yes or no? And we'll give you a couple of seconds to consider that and to vote.
We have a number of excellent questions, by the way.
We do. We have a number of excellent questions.
The corruption one is nice. The regulatory chill one is, they are very good. Very
exactly.
tempting.
Exactly. All right. Do we have the results from the poll? Good. So we have 94% are quite convinced. Our panel's been very convincing. So that's excellent. Let's move to the second of the three questions. If you can put that on the screen. There we go. I'm just waiting for the next question. Okay. Will expanding investment treaties in this manner increase the time and cost of arbitration? Yes or no?
Yes.
So if you have more counterclaims, are you ultimately going to reduce time and cost because you solve everything in one place? Or are you going to bring up all sorts of new claims and counterclaims? And the answer is, I'm going to bet the answer is yes, but I could be wrong here.
But people need to think of it as a non-linear function. It's
Yes.
not an immediate, and I think that's, think of it as in normal arbitrations. Would you have a claim and a counterclaim? The tribunal decides, but anyway, it's quite interesting. And I'm guessing like you that the answer could be yes, but we are now influencing people's mind.
That's true. There we go. There we go. So 72% felt yes, that would be the case. And then we have one final question. And if we can put that on the screen for the audience, would having further access to counterclaims increase the legitimacy of these treaties from the perspective of the public? Yes or no?
You know, Meg, let me tell you something about our part of the world as well. If we have now counterclaims tabled, there will be a wave of situations in every arbitration. The state will have to invoke a counterclaim so that no one would be accused of not using an option that was there, even if it's not a well substantiated counterclaim. So that's another aspect, another dimension of it.
Very good. Now, what is the answer on legitimacy? Do people feel it will increase legitimacy? What did the poll come up with? Aha, 84% feel it would increase the legitimacy. That's an interesting result. Well, that's fantastic. I want to thank everybody. This has been absolutely a very top-notch panel and a very engaging conversation. And in particular, thank you to the audience for tremendous questions. There are still a number of questions that are really thought-provoking, and maybe we'll try and get together and at least give you some kind of a little bit of a written answer. And we're also going to share the PowerPoint with registrants, so you will also have access to that. And I'd like to thank you for allowing me to be involved. I thought this was really an enjoyable conversation. So thank you to all, and I hand this over to Dr. Selim to finally close.
Thank you very much, Meg. I'm very grateful to you and to all the distinguished speakers. I'm also very grateful to the participants. We had throughout the webinar, much more than 100 participants. I'm also very, very thankful to my team, to Hiba and Yahya and their colleagues, Sharif, Sarah, everyone who has contributed to the success of this magnificent webinar. And I see that everyone has enjoyed this webinar, whether the speakers or the organizers or the participants. And I thank the participants also for their questions and their active participation to the poll. This is not the last topic. This is just the first topic. There are plenty of webinar series co-organized by Macchi di Cellere Gangemi and the CRCICA. So please be with us. We will be back again soon, early 2021.
Great.
Take care.
So thank you.
Bye.
Bye. Bye. Thank you very much.
Bye, all.